Good morning. The subcommittee will come to order. I'll recognize myself for an opening statement. For more than 2 centuries, America's economic strength has been built on a firm foundation. The rule of law, respect for individuals and private property, and the promotion of industry through policies that reward creativity and innovation are essential virtues that helped a fledgling nation encourage the initiative of its citizens and, in time, emerge as the most advanced and prosperous on earth. But these virtues are not universal. In an increasingly connected world, threats that emanate from areas where they are not shared can jeopardize our ability to sustain the incentives needed to foster growth and development and advance human progress. These threats create challenges for us in both the physical world and the virtual world, where the systematic and willful violation of intellectual property rights now poses a clear, present, and growing danger to American creators and innovators, U.S. consumers, and our collective confidence in the Internet ecosystem. Within that ecosystem today, there are legitimate commercial sites that offer consumers authorized goods and services. Indeed, many exciting new technologies and websites help content owners distribute music, movies, books, games, software, and other copyrighted works in ways that were not even imaginable 10 years ago. However, there are also what might be called online parasites or rogue sites that steal the intellectual property of others and traffic in counterfeit and pirated goods. The Merriam-Webster dictionary defines a parasite as, quote, something that resembles a biological parasite in dependence on something else for existence or support without making a useful or adequate return, end quote. In a very real sense, that is an apt description of how these sites operate. They depend upon the investments, creativity, and innovation of others while offering nothing of benefit in return. Indeed, according to the Motion Picture Association of America, websites that peddle stolen digital content represent, quote, the most pernicious forms of digital theft. And they present a two-pronged threat. They simultaneously weaken the film and TV industry by undercutting, eliminating, or reducing the market for film and television production, which millions rely on for jobs, and discourage legitimate companies from investing in new business models to provide high-quality content and more consumer choice online. Frederick Huntsberry, the Chief Operating Officer of Paramount Pictures, who is with us today, believes these sites, left unchecked, will decimate the motion picture industry. He describes an online shadow economy that distributes stolen property on a revenue-generating basis, diverting consumer spending from the creators into the hands of criminals, often outside the United States, and further robbing Americans of jobs and investments in new productions while depriving governments of tax revenue. In recent years, these websites have evolved. They've become increasingly sophisticated and rival legitimate sites in appearance, operation, and indicia of reliability. U.S. consumers are frequently led to these sites by search engines that list them among the top search results. After clicking on a site, they may be immediately reassured by the logos of U.S. payment processors and the presence of major corporate advertising supporting the site. But just how popular and profitable are these sites? One cyberlocker that is used to store and stream copyrighted content ranks as the 51st most popular website, while a business analysis provided by Paramount estimated a minimum annual profit of $41 to $304 million for one infringing cyberlocker. Who says crime doesn't pay? At the request of the subcommittee, the Acting Register of Copyrights, Ms. Maria Palante, who is also with us today, has been meeting with stakeholders to consider the issues associated with online parasites. One of her conclusions is that these sites exploit highly creative and economically valuable copyrighted works because there is no real expectation of enforcement. She notes that the most pressing issue is how to tackle sites based in foreign jurisdiction and observes that the continued evidence of widespread global Internet copyright infringement suggests that international cooperation alone cannot be the only solution to this global problem. Ms. Palante recommends that copyright enforcement follow the money within the Internet ecosystem and cut off these sites from U.S.-based revenue. She warns these sites undermine the incentives for legitimate commerce and threaten to weaken the robust, innovation-based markets that exist in the United States today. This matter has been a top priority and will become a principal focus for the subcommittee in the coming months. Today's hearing marks the first of 2 oversight hearings we'll conduct to make certain we are fully acquainted with the range of issues involved. I intend to take the time necessary to build a complete record and balance appropriately all the interests before introducing a bill that will contain meaningful and effective new authorities. As this process progresses, I look forward to working with members on both sides of the aisle and with our colleagues on the other side of the Capitol, as well as stakeholders in the private sector. With 19 million Americans employed in IP-intensive industries, we owe it to them and to ourselves to ensure any legislation we send to the President will be effective. It is important to note that whatever legislative product we enact will be only one solution to this problem. It is my strong hope that the stakeholders in content, technology, financial, and Internet communities will see any legislation we enact not as the end of this debate, but as the starting point for more discussions among the private parties to find additional innovative solutions to the threat of online piracy. It's now my pleasure to recognize the ranking member of the committee, the gentleman from North Carolina, Mr. Watt.
Thank you, Mr. Chairman, and thank you for convening this hearing. There is little disagreement that online theft of intellectual property is increasing and negatively impacting the rights holders and our economy. As the GAO found last year, the problem is sizable. The Internet has provided an explosion of e-commerce and a new marketplace for American innovators. Industries with heavy intellectual property interest have powered the American economy as the Internet has become a dominant venue for commerce. Today's hearing explores how to promote this commerce online by protecting the legitimate sites, but addressing the problems that have arisen as what the title to this hearing refers to as parasites. I actually think a more appropriate term for them would be parasites. Parasites, rogue websites, mostly foreign, engage in illicit conduct and are generally designed to pirate others' property for economic gain. A study from Frontier Economics estimates that in 2008 alone, over $650 billion was lost internationally from online counterfeiting and piracy. Counterfeit goods sold online on these parasites pose serious health and safety concerns. Just last night, 60 Minutes featured a segment on the sale of fake and tainted medicines and medical products that often come from illegitimate online pharmacies. Congress must take heed or run the risk that criminals and organized crime cartels who profit from piracy and counterfeit products hijack the Internet to the disadvantage of law-abiding citizens. At a time that intellectual property-intensive industries provide more than 19 million U.S. jobs and account for more than 60% of U.S. exports, parasites and the theft of intellectual property represents probably far and away the largest criminal enterprise in the world. And we're probably spending less to prevent it than we spend to counter old-fashioned bank robberies. In fact, electronic bank robbery is a much more significant threat now than armed bank robbery ever was. How we preserve due process and free speech rights, as well as confront this problem, will be critically important as we move forward. We cannot just go around and take sites down without due process or probable cause any more than we could arrest old-fashioned bank robbers only on suspicion. I look forward to hearing each of the witnesses' perspectives on the scope of the problem, and I hope that we will also hear concrete proposals for legislative solutions to help remedy this significant drain on our economy. I yield back, Mr. Chairman.
I thank the gentleman, and it's now my pleasure to recognize the chairman of the Judiciary Committee and one who has been deeply concerned and a leader on this issue, the gentleman from Texas, Mr. Smith.
Thank you, Mr. Chairman. This important hearing will point out the destructive effects of online parasites, those rogue entities that generate huge profits from the theft of intellectual property. The Internet is a wonderful tool that has forever changed the way we communicate, conduct business, and relate to one another. Most users want a safe computing experience and only use the Internet for lawful and legitimate purposes. But others employ it as a tool to perpetrate fraud, steal identities, traffic in counterfeit or pirated goods, or engage in even more disturbing crimes such as child pornography. Today, our focus is on the illicit trade in counterfeit and pirated goods. This committee has long recognized the positive contributions of America's intellectual property industries. They contribute 19 million jobs, more than 60% of U.S. exports, support tens of thousands of small businesses, and generate tens of millions in tax revenue for communities across our nation. IP enterprises drive our productivity, produce our entertainment, and promote our economy. But these industries face a threat in the form of exponentially increasing counterfeiting and piracy. A recent study revealed that 1/4 of global Internet traffic infringes on the rights of IP owners. Internet piracy is so profitable and pernicious that it discourages investments, innovation, and licensed content from legitimate companies. It is clear that existing laws are inadequate, and we must do more to confront the problem. Just over 2 years ago, then Chairman Conyers and I worked with other members of this committee, including the chairman and ranking member of this subcommittee, to enact the Prioritizing Resources and Organization for Intellectual Property Act of 2008, or PRO-IP. The purpose of that law was to strengthen American industry and protect American jobs by improving the government's response to the threats posed by counterfeiting and piracy. When considered on the House floor, PRO-IP passed by a vote of 410 to 11, a result that demonstrated our bipartisan commitment to IP protection. PRO-IP was a good start, but much more needs to be done. We will work to strengthen the law to ensure criminals who operate online are not able to harm U.S. consumers and steal from American innovators. Mr. Chairman, it is appropriate that Frederick Huntsberry, the COO of Paramount Pictures, is a witness today, since the present situation reminds me of a 1987 Paramount motion picture that starred one of my favorite actors, Sean Connery. In The Untouchables, Connery played Chicago detective Jim Malone. In a memorable scene, Malone tells Elliot Ness that if he is serious about getting Al Capone, then he must be prepared to pull a gun if one of Capone's gang pulls a knife. You all have heard that. For IP owners and other legitimate companies who have had to rely upon ineffective online enforcement regimes for far too long, it must seem that they've been forced to take a knife to a gunfight. It's time we help them fight back. We can no longer tolerate a state of affairs that requires U.S. citizens to be subjected to the illicit importation of infringing goods in violation of federal law and the constitutional protections that are designed to promote innovation and creativity. Mr. Chairman, I look forward to moving strong and appropriate legislation through this committee and appreciate the witnesses here today, and they're helping us accomplish that goal. I'll yield back.
I thank the chairman, and the chair now recognizes the ranking member of the full committee, the gentleman from Michigan, Mr. Conyers.
Thank you. I wanted to congratulate you, Chairman Goodlatte, on the way all of us have come together on this important subject. I'll put my statement in the record, but I'd like to get this started by offering a definition of rogue site, and it will be distributed. An internet site is a rogue site if it is primarily structured in order to and has no demonstrable or significant commercial purpose or use other than to offer goods or services in violation of Title 17, including by offering or providing access to, in a manner not authorized by the intellectual property owner or otherwise by operation of law, copies of or public performance or display of works protected by Title 17 in complete or substantially complete form by any means, including by means of download, streaming, or other transmission. Because that's what I think is going to be the important consideration for this committee. And I join in welcoming particularly the Chief Operating Officer of Paramount Pictures, our Register of Copyrights, and our two distinguished experts, David Sohn and Daniel Castro. Thank you, Chairman Goodlatte.
I thank the Chairman Emeritus for his remarks. We, by special request and agreement, are going to recognize one additional member on each side of the aisle for an opening statement. Then we'll ask all the members to put their statements into the record. And so the Chair at this time recognizes the gentleman from New York, Mr. Reed.
Thank you very much, Chairman, for this special consideration. I would like to thank Chairman Goodlatte and Ranking Member Watt for calling this important hearing today, as well as thank our witnesses who have agreed to participate. I firmly believe that criminal domestic and offshore websites dedicated to the online theft of music, movies, books, pharmaceuticals, and other intellectual property harm the U.S. economy, our balance of trade, U.S. employment, and put companies, consumers, and individual artists in New York and throughout the country at a severe disadvantage. What was once more about college students downloading music in their dorm rooms, online piracy has now grown to the point to where many U.S. companies and small creators are at risk of surviving. I am pleased to see bipartisan legislation introduced in the 111th Congress and the U.S. Senate by Senators Leahy and Hatch. I look forward to working in a bipartisan fashion in the House to address many of these same issues. Many have said that legislative activity aimed at reducing piracy could prevent free speech and shut down the technological infrastructure which the Internet was built upon. I, however, remain convinced that the popularity of the Internet in the first place is driven largely from the availability of high-quality copyrighted content, including films and TV programs that are delivered to users in innovative ways. I remain concerned these claims have yet to be fully vetted and hope this hearing and those to follow touch on these claims. Finally, I am hopeful for an open dialogue with all stakeholders in the Internet ecosystem as it relates to any potential legislation out of the Judiciary Committee. I am particularly concerned that inclusion of private right of action language and the prospective negative impacts on any legislation we put forward. In addition, I am hopeful the committee will be open to having discussions on search engines and how they relate to the popularity of various pirated websites. I look forward to any comments on these topics at today's hearings, and I thank the witnesses again. I thank you, Mr. Chairman, and I yield back.
I thank the gentleman. I think the award for earliest riser and greatest distance traveled to be with us today goes to the gentleman from California, Mr. Berman, and in appreciation for that, we want to recognize him for his opening statement as well.
Well, if that's the price of having an opening statement, I will exercise it rarely.
That's the strategy, actually.
Thank you very much, Mr. Chairman, for holding the hearing. I want to associate myself with yours and the other opening comments. In investigations, you follow the money, which is why many of us have invested time in trying to understand how those involved in the unlawful distribution of trademark copyrighted works are able to profit from their crimes. 5 or 6 years ago, we worked with Visa and MasterCard to stop the misuse of their financial networks by the notorious Russian music site allofmp3.com. We also need to turn a spotlight to online advertisers and are hoping that effective mechanisms are put in place to ensure that some of America's best-known companies and brands are not unwittingly helping to make piracy profitable. The fight against these parasites or rogue sites is difficult, especially when many operate from servers and registrars located outside the U.S., with the goal of selling pirated material into the U.S. In the Foreign Affairs Committee, the IP coordinator, Victoria Espinel, and the ICE director, John Morton, described the administration's innovative efforts to combat counterfeiting. They are trying new tactics because the anti-piracy tools we adopted in the past are inadequate to confront the crimes of today. As we evaluate new legislative tools, I've been wrestling with how to define the targets narrowly enough so that we can, on the one hand, rein in truly knowing infringers without leaving loopholes that provide a roadmap to criminals, or on the other hand, to put law-abiding sites at risk. I'm also wondering how we set up a streamlined process to address the whack-a-mole problem for seized sites that pop back up under a different name. By and large, I trust prosecutors to exercise their authority and discretion. Given the growth of online theft, the Justice Department may have even been too cautious for too long, but we must balance aggressive enforcement with real due process. And lastly, as an especially tough question for me, is whether, due to the lack of resources and competing priorities at DOJ, we should take some of the responsibility off law enforcement by setting up a mechanism that allows private parties to bring the kinds of actions that ICE is now bringing to protect their own property. There aren't any easy answers, no silver bullets, but it's long past time for saying no to every new idea. Thank you, Mr. Chairman.
I thank the gentleman. We have a very distinguished panel of witnesses today. Their written statements will be entered into the record in their entirety. And I ask the witnesses to summarize their testimony in 5 minutes or less. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. And before I introduce our witnesses, and as is customary for this committee, I ask that they stand and be sworn. Do you and each of you swear the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Thank you, and please be seated. Our first witness is Maria Palante, a senior advisor to the Librarian of Congress and the acting Register of Copyrights, a position she temporarily assumed at the beginning of 2011. The Register of Copyrights is a unique and important position. Among other duties, the Register serves as the principal advisor to Congress on matters of copyright policy. Ms. Palante has spent much of her career in the office, where she previously served as the Associate Register for Policy and International Affairs, Deputy General Counsel, and a policy advisor. In addition, Ms. Palante spent nearly a decade as Intellectual Property Counsel and Director of Licensing for the Guggenheim Museums in New York. She earned her J.D. from George Washington University and her bachelor's degree from Misericordia University, where she was also awarded an honorary degree of humane letters. Our second witness is David Sohn, the Senior Policy Counsel and Director for the Center for Democracy and Technology, CDT's project on intellectual property and technology. Prior to joining CDT, Mr. Sohn worked for nearly 5 years as Commerce Counsel to Senator Ron Wyden. Before that, he practiced law at a Washington, D.C. law firm. He earned his J.D. from Stanford Law School and his B.A. degree from Amherst College. Mr. Sohn has also a degree from the London School of Economics. Our third witness is Daniel Castro, a senior analyst with the Information Technology and Innovation Foundation, ITIF. Before joining ITIF, Mr. Castro worked as an IT analyst at the U.S. Government Accountability Office, where he audited IT security and management controls at various government agencies. Mr. Castro was also a visiting scientist at the Software Engineering Institute in Pittsburgh. He earned an MS in Information Security and Management from Carnegie Mellon University and a BS in Foreign Service from Georgetown. Our final witness is Frederick Huntsberry, the Chief Operating Officer of Paramount Pictures, where he is responsible for strategic planning and operations for the studio. Prior to joining Paramount, Mr. Huntsberry spent nearly a decade serving in a wide variety of executive and senior management positions at NBC Universal and affiliated companies, as well as at Vivendi Universal. He also spent over a dozen years with General Electric's Europe division. Mr. Huntsberry has a bachelor's degree with a concentration in finance from Boston University. We welcome all of our witnesses to the Subcommittee on Intellectual Property, Competition, and the Internet today, and we'll begin with you, Ms. Palante. Welcome.
Thank you, Mr. Chairman. I would like to express my gratitude to you and Ranking Member Watt for having this hearing today and for elevating the importance of copyright protection in the context of online commerce. I also would like to say that my office greatly appreciates the support of Chairman Smith and Ranking Member Conyers on these issues. As you know, the U.S. Copyright Office is undergoing a leadership transition following the retirement of Mary Beth Peters, and I wanted to take a moment to assure you that our staff is very busy carrying out the work of the office, including registering copyrights, eliminating the backlog, securing works for the Library of Congress, and perhaps most relevant for this hearing, studying and advising on domestic and international copyright issues. Copyright promotes innovation by extending a number of exclusive rights to creators, including the rights of reproduction, distribution, the right to make derivative works, the rights of, and in some instances, the rights of public performance and public display. Our law grants these rights, but they are of little value to anyone if they cannot be effectively enforced. There's nothing redeeming about parasites or rogue sites that are entirely or substantially committed to infringement. They exploit copyrighted works with impunity because they have little or no expectation of enforcement. And to be clear, we are talking about activity that does not constitute fair use and cannot be qualified for any other defense available to good faith actors under the law. In support of the subcommittee's work on this issue, my staff and I have met with a broad spectrum of stakeholders, and we will continue to do this in the weeks ahead. The issues are complex, but they present an opportunity for Congress to manage the relationship between technology and intellectual property, as it has done many times before. Rogue sites can be located anywhere in the world and have a devastating effect on U.S. books, software, music, movies, and television programming. Unlike traditional brick-and-mortar infringers, they can be quite difficult to identify and locate, and when pursued, may simply and quickly reappear under another domain name. Those based outside the United States lack sufficient ties to be compelled to appear before U.S. courts or to allow the enforcement of a judgment against them. It can be difficult for rights holders, especially small rights holders, to litigate in foreign countries or to enforce a judgment abroad. So what can be done? Solutions that follow the money, for example, sales, subscriptions, and advertising revenue, may be most successful. Payment processors like credit cards and PayPal are essential to the web-based commerce we all enjoy. But rogue sites have no business using trusted companies to process profits. Likewise, many rogue sites display advertising, allowing them to run lucrative businesses using copyrighted works as the hook. Search engines are perhaps the most important, perhaps the most impressive player in the ecosystem. Without them, the internet would be almost impossible to navigate. Unfortunately, both paid and unpaid search results routinely point people to rogue sites. One solution might be to give enforcement entities like Immigration and Customs Enforcement increased authority. For example, ICE could request a court order requiring payment processors and ad networks to sever their financial ties to rogue actors. Congress might also review the role of domain registrars, registries, and internet service providers. A harder question for Congress is whether it is reasonable and viable to ask search engines to participate in a solution by suppressing the search results that send users to rogue sites. Safeguards are important. Some have warned that some of the proposed remedies would risk fragmenting the Internet's global domain name system. These assertions would require careful examination. It might also be helpful, however, if the dialogue that Congress seeks includes the council of experts who can objectively evaluate these relevant technical facts. Principles of due process and freedom of expression are also critical. Even the worst of the worst should receive notice as well as an opportunity to be heard, and relief should be narrowly tailored. However, injunctions have long been used in copyright cases, and we do not believe that an order that shuts down a website dedicated to infringement would violate the First Amendment. Mr. Chairman, thank you again for inviting me to testify, and I await any questions that you or the subcommittee may have.
Thank you, Ms. Palante. Mr. Stone, welcome.
Members of the subcommittee, on behalf of the Center for Democracy and Technology, thank you for the opportunity to participate in today's hearing. I'd like to say at the outset that CDT recognizes the problem posed by online infringement. Large-scale copyright infringement affects not just rights holders, but also the growth of new media, e-commerce, and online expression, all of which are values that CDT works hard to promote. The main point of my statement today, however, is to emphasize that the tactics chosen to fight infringement matter a great deal. Some tactics might seem superficially attractive, but would not work very well in practice. Some tactics could do a lot of collateral damage, for example, by inadvertently impairing lawful online speech, lawful online communications tools, or by undermining cybersecurity. And some tactics, and particularly the domain name-focused tactics that I discuss at length in my written testimony, suffer from both problems. They won't have much impact on infringement, and they risk doing significant inadvertent harm. What I'd like to do with the rest of my time is briefly list some general principles that Congress should keep in mind as it considers policy approaches in this area, and then turn to the specific question of domain name blocking and domain name seizures. So first in general, one, enforcement tactics should keep a targeted focus on the true bad actors and be careful to avoid impact on lawful businesses and speech. Doing that requires a narrow focus on purposeful wrongdoers, and it requires sufficient due process to avoid mistakes. Two, proposals for new law in this area, really as in any area, should be subject to careful cost-benefit analysis. If there are policies that offer small or ephemeral gains at high costs, that obviously doesn't make much sense. And three, when the infringers are overseas, cross-border cooperation is essential to stop the illegal activity at its source and shut down the wrongdoers for good. Congress should not assume that the best approach to foreign infringement is necessarily a new domestic law. Now let me turn to the specific question of going after infringement websites by blocking or seizing their domain names. As I think the members of this subcommittee know well, the Senate Judiciary Committee last year considered legislation to expand this practice by, among other things, asking Internet service providers to block domain name lookup requests. The first thing to understand about this tactic is that it does not actually remove bad sites from the Internet. Nothing gets shut down. The servers and all the infringing content they contain are still there online. If the domain name has been seized, the site operator can quickly hop to a new one, this time using a registrar outside U.S. jurisdiction. And as for the users, my testimony lists several completely easy ways they could reach a site whose name has been blocked or changed. The ways aren't highly technical, but for those users to whom it still seems complicated, software tools would quickly spring up to automate the process. So the bottom line is that domain name tactics will have rapidly diminishing returns. The more common the interference with the domain name system, the more these workarounds will go viral, and the more they will become routine. And I think at the end of the day, any actual impact on infringement will be fleeting at best. Meanwhile, domain name tactics risk collateral damage in a number of areas. First, the tactics will have some impact on lawful speech. It's important to realize that targeting a domain name affects all the content at that domain. It's different than, for example, the DMCA notice and takedown process, where only the specific infringing material is targeted. Plus, there are many domains that are shared by literally thousands of individual sites, and we've already seen concrete examples of mistakes and overbreadth because of this. In February, ICE mistakenly seized a domain with 84,000 subdomain registrations. The result was that numerous innocent people, personal bloggers, small businesses, and so forth, had their websites replaced with a banner that read essentially, "This site has been seized due to child pornography." Needless to say, that's a very damaging allegation to have made against one. Second, there are serious technical and cybersecurity concerns. For example, domain name blocking is technically incompatible with DNSSEC, which is a standard for protecting the security of the domain name system that's been a decade in the making and is just rolling out. In addition, the technologies that users would, or excuse me, the techniques that users would employ to circumvent blocking can create new cybersecurity risks as well. Finally, targeting the domain names of purely foreign sites would encourage a dangerous jurisdictional scrum internationally, with each country potentially trying to use the domain name system to enforce domestic law against foreign sites. So I think Congress has to consider the international implications and the precedent it would be setting. For all these reasons, I believe that codification and widespread use of domain name-focused tactics would fail any serious cost-benefit analysis, and I'd urge Congress not to go down that particular path. Thanks for the opportunity to appear today.
Thank you, Mr. Stone. Mr. Castro, welcome.
Chairman Goodlatte, Ranking Member Watt, and members of the subcommittee, I appreciate the opportunity to appear before you to discuss strategies for dealing with these so-called parasitic or rogue sites on the internet. These websites steal American intellectual property either through engaging in digital piracy or selling counterfeit goods. Rogue sites stunt economic growth, eliminate American jobs, and put U.S. consumers at risk. The problem of digital piracy has become so pervasive today that 1 in 4 bits traveling on the internet is infringing content. With just a few clicks, internet users can download pirated copies of full-length Hollywood movies, watch unauthorized video streams of live sports games, and illegally download software to use on their computers. Sometimes it's even easier to find pirated content on the internet than legitimate content. To give just one example, I recently performed a web search for Watch Inception online, and there was not a single link to a legitimate website in the first 2 pages of results. Instead, I received a list of rogue sites that earn ad revenue every time a user watches the movie illegally. Consumers shopping online are also exposed to counterfeit shoes, counterfeit goods including prescription drugs, cosmetics, handbags, and shoes. Not only are these counterfeit goods often of poor quality, many counterfeit items such as infant formula or baby shampoo have been found to be harmful to human health. Here too, the problem is substantial. A recent study found that traffic to 48 sites selling counterfeit goods averaged almost 250,000 visits per day. This translates into serious consequences for our economy. One group estimates that counterfeiting has directly resulted in the loss of more than 750,000 American jobs. Currently, rogue sites operate in a low-risk, high-reward environment. Site operators, especially those outside of the United States, face few personal risks from law enforcement and encounter few, if any, barriers to distributing illegal content online. We need to change the equation. More can be done to help reduce online infringement, including the following. Create a process by which the federal government, with the help of third parties, can identify websites around the world that are systematically engaged in piracy or counterfeiting. Enlist ISPs to combat rogue sites by blocking them. Implement notice and response systems for repeated infringers, and impose data caps where necessary. Enlist search engines to combat IP theft by removing rogue sites from their search results. Require ad networks and financial service providers to stop doing business with websites supporting IP theft. Create a process so that the private sector can consult with government regulators on proposed uses of anti-piracy or anti-counterfeiting technology. Use NSF or NIST to fund anti-piracy and anti-counterfeiting technology R&D. And finally, pursue global frameworks to protect IP internationally and impose significant pressure and penalties on countries that steal from the United States. The purpose of these actions should not be to target minor violations of the law, but rather to target websites primarily designed to steal intellectual property. New tools are especially needed for foreign rogue sites, such as the Pirate Bay, a Swedish site dedicated to stealing software, movies, music, video games, books, and other digital content. One way to address these sites is to block them at the DNS level. DNS is like a global phone book for the internet, where providers use the numbers that provide users the number that corresponds to each name. Using DNS to block rogue sites is fairly straightforward. DNS servers can be instructed to no longer resolve an IP address when users look up the domain of a known rogue site, Without this IP address, users would not be able to go on and visit these sites. Basically, this would be like taking a list of criminal organizations out of the phone book. Some opponents of better enforcement of IP claim this will disrupt the internet. I'm here to tell you this claim is 100% false. The simple fact is that using DNS to block access to websites or servers is not particularly new or challenging. DNS redirection has been used for many years to block spam and botnets and to protect users from malware. It's also widely used to provide parental control filters, correct typos in URLs, and to provide improved search results. Another objection some critics make is that blocking rogue sites contradicts the idea of a free and open internet. However, websites that egregiously violate the law at the expense of American consumers and American workers have no place on the internet. Democratic nations are well within their rights to use clear and transparent legal means to enforce IP rights online. The responsibility for maintaining the internet falls upon each user, each service provider, and each business and institution that uses it, operates it, and profits by it. I encourage you to put in place the frameworks and policies needed to facilitate and encourage all actors within the internet ecosystem to take some measure of responsibility for maintaining its integrity and protecting consumers. Thank you.
Thank you, Mr. Castro. Mr. Huntsberry, welcome.
Thank you, Chairman Goodlatte, Ranking Member Watt, and the members of the subcommittee for holding this important hearing. I am Frederick Huntsberry, Chief Operating Officer at Paramount Pictures, and I appreciate the opportunity to appear before you today. I'm here to discuss the theft of motion pictures and other American-made products via the internet, the devastating impact the business of theft has on the U.S. economy, and the need for legislation to enforce the rule of law on the internet. An online shadow economy has emerged that operates in parallel to our legitimate economy. In this online shadow economy, every single film we distribute is stolen and then illegally made available online. Other forms of content like TV shows, music, games, books, and software are also illegally distributed for profit. The U.S. film industry creates jobs and tax revenue across America, ranging from advertising expenditures to employment at movie theaters to retail jobs selling DVDs. But it is often overlooked that motion pictures are also shot in all 50 states, creating local jobs, supporting local small businesses, and generating significant revenue and tax dollars all across the country. A typical Paramount motion picture will employ anywhere between a few hundred to many thousand American workers. We also spend money in states across the country. Last year, True Grit was shot in Texas and New Mexico, adding an estimated $16 million to those local economies. The Last Airbender was shot in Pennsylvania, adding an estimated $72 million to the local economy. Paramount embraces technology, and we believe that consumers will increasingly choose to view our films via authorized internet distributors like Netflix and iTunes today. Already today, we license our films to more than 200 online digital distribution platforms across more than 70 countries, covering more than 750 films in more than 25 languages. The online shadow economy does not create any American jobs. It does not reinvest any revenue in the creation of new films or goods. It does not pay taxes, and it does not contribute to the U.S. economy. Instead, it steals from the U.S. economy and enriches thieves. Today, an online search for movies leads consumers away from legitimate services by providing results for numerous sites that will lead the consumer to stolen content. It's so simple and convenient that consumers may never know the difference. Some of these websites look like legitimate sites, accepting credit cards and displaying ads for well-known products. Further examples of these are in my written testimony. Let me draw your attention to the screens in the room. Just to give you an example how simple it is for a consumer who's looking for legitimate ways to stream content online to find the content. So you can be in Google and type in stream, just the word stream, and you will get actually an autofill from Google that says stream movies or stream TV shows, as well as a list of websites ranked in popularity. Turns out all the websites highlighted in yellow are actually pirate websites. We're going to select the first one, solarmovie.com. This brings us now to a site that is a search engine called solarmovie.com, and this search engine finds pirated content on the internet. We can see here movies that have been released over the last few weeks, as well as Grease. We're going to select now The Adjustment Bureau, which was released by Universal last week. And then we are brought to a screen where we can see all the cyberlockers, meaning the storage websites, where the film is located. We're going to select videobb.com, and 2 more clicks later, we're actually streaming the movie. Within 6 months after Paramount released Iron Man 2 in theaters, a camcorder copy was available in 12 languages. There have been more than 15 million peer-to-peer downloads, and more than 153,000 internet links were made available for download or streaming. 20 internet storage sites, also known as cyberlockers, account for 96% of all infringing copies of Paramount films found on cyberlocker sites. These 20 cyberlockers received a total of 177 million unique monthly visitors in February of this year. They use incentive programs to encourage the uploading of stolen copies of motion pictures. These programs pay cash to the person who uploaded the content every time their content is downloaded or streamed. Enormous profits can be made trafficking in stolen motion pictures. We estimate that Mega Upload, for example, earns an annual profit of 40 to 300 million. We have reached the limits of self-help. Last year, Paramount sent over 40 million infringement notices, yet the same content is still a few clicks away. Legislation focusing on rogue online services is profoundly needed to establish the rule of law on the internet. Doing so will not only benefit the countless American jobs and millions of dollars in tax revenue that are currently being lost, but it will also allow the internet to fulfill its full commercial promise. Thank you again for affording me the opportunity to present my views here today.
Thank you, Mr. Hunsberry. I will begin the questioning with you and to the very point that you've raised. Where do you see the motion picture industry in 5 years or so if we don't anticipate and provide the necessary tools to ensure effective online enforcement of IP rights, at least within U.S. borders?
Well, I think the future can be described as one of less volume and different type of product. If you look at the history of this industry, it has been one that was never constrained by theft or piracy, and therefore was able to produce as many films as the market afforded, the opportunity that was created. As a result of the theft that has been going on already over these last 5+ years, we have seen a dramatic reduction in the number of films produced. The 6 major motion picture studios used to produce over 200 movies just 5 years ago. We're down now to 140 movies as of last year. And also the profile of movie has changed, meaning that we are concentrating more and more on movies that we believe can at least withstand the pressures that piracy is putting on us. That means that movies that are sort of in the mid-budget range, which is sort of a $50 to $100 million range, which are dramas with a smaller audience, just have a very hard time right now reaching audiences. So, as I said, we're going to see lower volume going forward, and we will see more changes in the profile, which means there will be less choices offered to consumers.
Thank you. Mr. Sohn, with that in mind, you stated that addressing foreign infringement activity requires international cooperation. But what if the hosting country fails to act, or, as in the case of the Pirate Bay, the service hops to another country? Why should the U.S. be held hostage to hostile, corrupt, or uncooperative foreign interests? Don't we have the right and responsibility to protect U.S. consumers who are targeted by malicious foreign actors? And shouldn't we protect U.S. creators who play by the rules?
Sure, and I think we ought to be looking for ways to do that. I do think that as a starting point, though, it's important to recognize that actually trying to punish and catch actual bad actors is really the way you get the most bang for the buck. If you can do that, you can actually get the problem at its source. So we have efforts underway to improve cooperation with other countries. There's a chapter on that in ACTA. It's part of the IPEC annual report. The IPEC, I think, was here and listed a number of efforts in that area. I think it's essential to pursue that kind of international cooperation. And in fact, there was a report that Mark Monitor put out in January that said that the bulk of digital piracy sites are actually based in North America and Western Europe. So I think actually a lot can be done cooperating with our known trading partners. For that category of sites where we can really go through the tools on the table and see that they don't work and it can actually be shown, I think it's worth thinking about whether there are narrowly targeted congressional actions that could work. And the phrase I've heard several times today is follow the money, and I think that would be a fruitful path to explore.
Thank you. Ms. Palante, in your opinion, has U.S. copyright law kept pace with technology?
Well, I think Congress has done a very good job over the last 100 years of catching up to technology, but we're rarely out in front of it. And the great thing about this issue is that it's a chance for us to ensure before we go over a cliff that there's a vibrant e-commerce environment so that there are incentives. So it's not just about going after the content that we already know is infringing, but by providing a safe environment, we can provide incentives for commerce to flourish.
You noted that operators of these parasitic websites have no real expectation of enforcement. What are the most important steps that we might take to put teeth in our enforcement measures?
As we said, we've been talking with a lot of stakeholders who have a lot of views on this, but the theme that has emerged is that by starving them from financial ties like credit card processing and PayPal and advertising revenue, that would go a long way towards reducing the impact. Not all of them operate with direct financial motivation, but it would help a lot to start there.
Thank you. And finally, about a dozen years ago, I spent many weeks in a cramped room, warm, hot room downstairs in this building with many of the internet service providers, many representatives of the content community, some companies that had a foot in both camps, and we negotiated some of the key provisions, particularly the notice and takedown provision of the Digital Millennium Copyright Act, which is, as you know, the principal tool copyright owners have to protect their intellectual property online. It was written at a time when relatively few people were connected to the internet, and those who were generally had a maddeningly slow connection. Looking forward, do you think the balance struck in the DMCA provides appropriate respect and protection for creative works, or do we need to take another look at it?
Well, that's a big question.
It is.
I think it always helps when Congress takes a look at existing law that relates directly to technology. So we would not be afraid of that process. It is an important tool, the takedown, and a lot of good companies have built into their business practices ways to deal with those. Others don't. They ignore them. They're not set up for them. They're set up so that they have automated systems that repost the content immediately through computer software. So so there's that. And in this context that we're talking about today, Chairman, the DMCA doesn't help with the offshore rogue websites.
Thank you very much. Chair now recognizes the gentleman from North Carolina, Mr. Watt.
Thank you, Mr. Chairman. I'm not sure exactly where to start here. So many issues. Ms. Palenti, let me be clear first that although your testimony is directed at copyright, are there also similar problems in trademark infringement and other areas, and whether you would treat those areas the same way as you would in the copyright area?
Thank you for the
or
question.
whether there's an impediment to doing that.
There are clearly very important trademark violations and counterfeiting problems relating to drugs, relating to toys, and relating to generally to consumer products. They were not the focus of my testimony because we administer the copyright law in my office.
So but my point is, whatever system we set up to deal with one industry, we probably need to set it up to deal across the board, right?
Yes, I think
All right, that's not, I'm trying to cover a lot of territory here. I just want to be clear on that. Mr. Huntsberry, you described, you gave us these visuals on a number of things that you all license, and you have pretty good information about the people who are pirating. There seems to me to be a dual track here that has to be being pursued. That's one is on the criminal side, and one is on the civil side. I thought you put up identified 18, 20 sites that were doing 80, 90% of the pirating. What are you all doing on the civil side to pursue those, or is there some impediment to doing that?
No, what we do is we work through the MPAA to take action against those sites.
Why is that not a individual business imperative? I mean, given the extent of this, you're working through an association to do it,
Right,
as
that's
opposed
right,
to
because
doing it?
all studios are affected by the same sites typically.
Okay, but what is the MMPA doing to really aggressive? I mean, can they bring a lawsuit in
Yes,
the name of?
In the name of some of the studios, that's correct.
Yeah, okay. You also put up, identified on the screen the companies that you all license to do this. Is there any way that electronically or technologically you could require before something is shown some kind of discrete identification that would enable it to be easier to identify the rogue sites? You understand what I'm asking?
I do, and I appreciate the question, because the problem we run into is that we
Somebody
find
would
that
pirate that too, huh?
Pardon me?
Somebody would pirate the
Exactly. That's
unique
exactly what happens
identifier.
today. In fact, McAfee, which is a well-known, protective software for consumers, their logo is stolen and then used on the pages where the rogue sites are asking consumers.
There's got to be something more than a logo. I mean, I'm talking about some unique identifier of some kind.
Yeah, but it's, again, what happens is whatever you flash up can be copied by others. We even have an example where a rogue website was luring consumers with a well-known brand URL, www.redbox.com, which is a well-known company that licenses legally or that rents DVDs in stores, and they were using that brand name to then send consumers to a rogue website.
Okay, maybe in California you see a lot more coverage of this, but I've seen very little coverage of any civil litigation about this. Am I missing something here? Is that being aggressively pursued, or?
We're definitely pursuing it wherever we can, absolutely. But
it doesn't seem to be getting much coverage.
Well, many of the sites, also have to remember, are outside the United States, and so it becomes also more difficult to go after them, because there's the question about where does the management reside of the
But law enforcement has, domestic law enforcement has that same impediment going across into another country.
Well, that is part of the issue that we have here today, is that we cannot go after the foreign sites.
All right, my time has expired all too quickly. I will lead on the next round if we have one.
No, we go to Republican next. The gentlewoman from Florida, Ms. Adams, is recognized for 5 minutes.
Thank you, Mr. Chair. Ms. Palante, I want to thank you for coming and agreeing to meet with the stakeholders and everything to investigate this matter. Can you give us a sense of the process you've gone through, the types of stakeholders you met with, and what themes are emerging from those discussions?
Yes, thank you very much for the question. In the last month, we've had over 30 meetings with probably over 50 stakeholders, really in a fact-gathering approach. And we've met with everybody from small representatives of small authors, book authors, for example, to corporations that are in the music or movie businesses. We've met with search engines. We've met with ISPs. We've talked to payment processors. So we've really tried to cast a wide net. We've also met with ICE, and we've met with the FCC. Because there are other government entities that come into play on this, and they have very valid perspectives that have been quite helpful to us. So we're still studying the issues, and as I keep saying, they are very complex, but in general, the complexity in the view of most stakeholders, is not a reason not to approach the issue. In other words, just because these technical pirates may be so smart and may get around anything that you may enact is not a reason not to go down that road. Most people do agree that there should be a role for all who benefit in the ecosystem, and there should be a mix of legislative and private kind of procedures and practices that come into play to solve it. Due process is extremely important, and everybody agrees with that. And the remedies should not affect the current doctrines of copyright liability. In other words, these are really about remedies.
Search engines, I know you noted that search engines are perhaps the most important player on the online ecosystem, and stated search engines have sought algorithms that currently often provide internet users with search results for rogue websites, but technology may exist to allow search engines to block such sites from appearing in the search results, much as search engines have eliminated child pornography from the results. So as part of your discussions, has the Copyright Office attempted to engage the search engine community? Do you think it might be productive to discuss the adoption of voluntary agreements to address the piracy through either the removal of the illegal sites in search results and or giving prioritization to authorized domains in search results?
I think all voluntary cooperation is a part of this. The question is, can the suppression of searches to rogue sites be possible technically? Is it viable? Would it ruin the process that search engines engage in for good faith customers and in their good faith business? We don't know the answer to the technical questions in the Copyright Office, but we think that they need to be explored.
You do agree they do need to be explored, correct? I mean, I think that we need to be looking at all avenues to try to at least discourage the rogue sites from popping up so quickly. I'm curious, and maybe anyone, but what would you see as Congress's role to the new, if they were to grant new authorities to the federal agencies? You know, what resources do you believe they would need?
I think what we need is the ability to go after foreign rogue sites, first and foremost.
Mr. Castro?
I would just echo what's been said here today, that it needs to be comprehensive. Too many of these recommendations are only looking at domestic solutions, and piracy, as we know, is global. So yes, it needs to be a global solution.
In terms of resources, I would say it's especially important that law enforcement has the resources to pursue actual cases against bad actors and to do the hard work of working with other governments to try to pursue entities that are abroad as well. I think some of that can be done. I'm sure it is resource intensive.
You're grinning.
Yes, I think our law enforcement entities have something like 400 federal laws that they're responsible for enforcing. So assuming they're doing the absolute best that they can, they would need very clear parameters about what they can go into court and request a court order for. So could they shut down payment processors? Could they ask ISPs to block? They would need to know exactly what the parameters of the law were before they undertook the resources to go after these kinds of sites.
So very clear and distinct legislative laws.
Yes.
And I would agree, coming from the law enforcement community. Thank you.
I thank the gentlewoman. The gentleman from Michigan, Mr. Conyers, recognized.
Thank you, Chairman Goodlatte. This sounds like a 101 in copyright law, in which everybody redescribes the problem in their own unique way. But you know, the purpose of a hearing is for the witnesses to come to us and give us some recommendations. And so far, I haven't gotten one concrete recommendation about what we do. You're all describing the problem. And I'm disappointed in all of the witnesses. I mean, here's a $1 trillion industry losing billions of dollars every year. The Judiciary Committee holds a hearing, and what do you four come and tell us? That this is a big, complicated problem. Much of it is offshore, so we can't do anything about it. And the question comes down to, when this is all over, we're going to read through this transcript and say, what did we learn? And I can tell you what I've learned. Now, let me take the rest of my few minutes and ask you each one specifically, starting with Paramount, what do we do in the Congress?
Right. So as I said earlier, is we need to have the ability for law enforcement to pursue the owners of foreign rogue websites. That is one of our biggest hurdles today. These sites know exactly how.
You mean you don't have lawyers that have recommended something specific to you?
Sure, but therein.
Well, why don't you tell us?
Because therein lies the problem. It is today impossible to even discover who the owners are of these sites, as well as where the sites are served. So
Hey,
it
that's
becomes
an
very
excuse.
complicated.
That's not answering my question. What do you say, Mr. Expert?
There's a number of recommendations that we have that are very specific about what you can do.
Name them.
So you can block at the DNS level foreign sites and domestic sites that are systematically engaged in piracy. You can require search engines, ad networks, financial service providers to stop doing business with these sites. You can create a process for the federal government to work with industry to identify these sites, create a list of all of these sites, and then with this list, once you know where all the rogue sites are, you can work to create a culture that rejects piracy. As you've pointed out, we all know this is a big problem. If we had a list and said, here are the top 1,000 sites that are engaging in piracy, everyone in the internet needs to be involved in doing this. You can use a carrot, you can use a stick, you can use a gentleman's agreement, but you can get it done if you have that list.
I wish that I had an easy answer for you for a way that
I'm not looking
that would
for an
solve the
easy
problem.
answer.
So, but here's what I'd suggest. Number one, I think Congress needs to continue the process that started with the Pro-IP Act of trying to improve our law enforcement capability, make sure that we are as effective as possible in our actual prosecution of bad actors. And that requires the hard job of working with other countries, and I think Congress has a really important oversight role there. I think that it is worth looking at narrowly targeted ways to address situations where we can show that that process can't work. In other words, ordinary law enforcement can't work. And the approach I would recommend that Congress look at is this follow the money approach that has been discussed a couple times today. I think that trying to make sure that rogue websites can't make a profit, can't turn this into a profitable business enterprise, would be an important step.
At this stage, our primary recommendation is exactly that you find a way to give enforcement entities like ICE the authority to request a court order to ask payment processors and ad networks to cut off their financial ties to rogue sites.
Thank you, Mr. Chairman. I can see why the industry's losing so much money. How many times do you think this committee is going to have hearings on this subject in the 112th Congress? Well, this may be it. So I thank you, Chairman Goodlatte.
I thank the gentleman, and the chair now recognizes the gentleman from New York, Mr. Reed, for 5 minutes.
Thank you, Mr. Chairman. I am going to go down a path here that Mr. Conyers is kind of exploring. When I've looked at this issue, I've looked at it from a traditional model of historical thinking that this is a common theft situation and we need to arm our law enforcement with the traditional means and methods of enforcing the laws and go after those offenders. One thing that I've been asking myself recently when looking at this issue is there something that we're missing that the Internet presents to us in a new environment? Is there something within the Internet itself, technological protective measures or enforcement measures we could be arming our law enforcement with to go after these offenders? By that I mean the chairman of the full committee in his opening comments said something about if you go to if you're getting into an armed robbery situation, you make sure you go in and cut off the offender. Is there something that the technology offers us to utilize to go after these offending entities that are engaged in this clearly illegal activity? We go through the courts, we get the appropriate measures, but is there something that technology can provide to us that the law enforcement would be looking for in order to go after the offending parties? And I guess I'll go to the government office to see if as law enforcement have any ideas that could be of assistance to us?
Thank you for the question, and just to be clear, our office is not a law enforcement.
I understand that. I understand. But from the government, from your dealings with the Department of Justice and whatever.
Yeah, in the greater government family, the law enforcement piece is obviously the big hammer. It has to be there, or there's no real expectation of enforcement. The technology has really been a huge investment on the part of private rights holders. They've done everything they can to track infringement, to bring infringement to the attention of ISPs, for example, so that they can put takedown notices out there in the hopes that people will comply. One interesting question is, what responsibility, if any, should those who host sites have in employing technology, say filtering technology, to weed out infringement as a good corporate citizen?
Okay. Any other suggestions? Any other tools that could be at our disposal that we're missing, given the nature of the Internet and its technological advancement?
I think at the end of the day, there are some limits to what technology can do here. Information technology puts powerful tools in the hands of users, and I think in the long run, the solution here is not going to be so much the users not having the technological capability to reach bad sites, but is going to be more trying to develop some norms and some deterrents that prevent people from using it that way. I think technology can play an important role as different entities in the ecosystem try to roll out tools to stop. For example, technology can be used to make DMCA notice and takedown processes more effective, more streamlined. So I think there's lots of ways that individual entities within the system, within the ecosystem, I should say, can be more effective in the role they're trying to play. And that can include, for example, YouTube, which has a process right now for trying to identify infringing videos when they're uploaded, and for for allowing rights holders to monetize that. So I think there's lots of ways that technology can be deployed. I think that the difficulty is that there's unlikely to be a one-size-fits-all technology solution, and it would be difficult for Congress to go down the path of trying to mandate particular technologies here. This is something that different players have to explore.
Okay. So I guess what I'm hearing here, and I don't mean to cut you off and run out of time, is we really have 2 points of potential areas to look at this from the money perspective, and also from the structure of the Internet perspective. Am I clearly understanding? Does anybody disagree with those 2 points of areas of where we can step in and potentially attack this issue? Are there any other areas out there?
I see it as money and technology.
Money and technology.
That's right.
Anyone else disagree with that? Okay. What other, when we deal with the size of the enforcement mechanisms we need, are there any limits that we should be considering on the size of the penalties or tools that are at our disposal? Or should it be just fully unlimited? Anyone? Ms. Palenta?
Well, one question that's been raised in the stakeholder discussions that we've had is whether there will ever be enough government resources for the government to pursue this as a priority, this being infringement or counterfeiting, for example. So even if the law were changed and it were clear and they had more of an ability to cut off the money and to starve these rogue websites and to get at the offshore operators and to block those sites here, the question would still be, would you still be ahead of the problem? Or would you still be limited to kind of the really, really big, grossly infringing sites? And so the question that I think is down the road is whether there should be some additional right of private actors to get into court on their own without always going through the Department of Justice or ICE, for example. And you'll hear that from stakeholders as you talk with them.
Okay, thank you. I yield back, Chairman.
Thank the gentleman. Chair now recognizes the gentleman from California, Mr. Berman.
Well, thank you very much, Mr. Chairman. Mr. Sohn, one very quick, hopefully answer to a quick question. You write in your testimony, CDT recognizes the problem of websites that seek to profit by distributing copyrighted material without authorization and without paying the lawful rights holders. Having a debate on what you meant. Is it one or the other, or even if they're paying the lawful rights holders, if they did it without authorization, that's wrong and you oppose it?
I think all we intended by that phrase was to refer to entities that are violating the law because they have not properly licensed the materials that they're distributing.
So paying rights holders what you think is just compensation if you don't have their permission or a license from them is still wrong.
Correct. I was envisioning by that phrase a voluntary transaction in which the rights holder is paid a licensing fee that the rights holder has agreed to.
Okay. Mr. Sohn's testimony, as he says there, acknowledges the problem, talks about solutions that involve the forfeiture and blocking of a website as ineffective. His testimony, if you have a chance to read in detail, it's filled with lots of very interesting things, which we can't do justice to in 5 minutes. But challenging the effectiveness of this approach, raising issues about the potential for encompassing websites that may be doing some infringing work, but also are exercising non-infringing First Amendment expression, raises the philosophical question of the right of U.S. law to try and affect behavior by parties in other countries, and then raises consequences of that approach in terms of cybersecurity and inefficiencies in terms of the internet functioning. Mr. Castro, I don't know if you've read the testimony, but I'd like to get your reaction to some of the points Mr. Sohn raised in his much longer written testimony.
Absolutely, and obviously in a shortened time, if you look at my written testimony, I believe I've addressed all of those objections that have been raised. They've been raised in a number of forums before. If you look at the issue of DNS blocking, which is I think where most of the objections have been raised, or blocking even at the IP level, this DNS blocking is something that's used already today. There's a service, for example, called OpenDNS. People actually subscribe to this service, and this service provides users a number of tools like parental controls. It corrects typos in URLs, and it ensures people get to only safe sites. We can do something very similar with DNS blocking for rogue sites. If you look at the objections that are raised, most of them are speculative. If you look at the data, there's none that supports it. And if you look at what even the creators of DNS, for example, Paul Vixie, he runs ISC, which is the company that creates Bind, which is the software that actually runs DNS on the computers all over the world. He's even come out and said that the idea that any site should be able to just have a domain name if they're a rogue site, that you should be able to, the purpose of DNS is not to facilitate rogue sites. It's not to facilitate piracy. It's not to facilitate counterfeiting. we can change the way these standards are written to respond to this. We can create secure DNS protocols that allow for the types of controls and mechanisms that we're talking about today that would allow you to block rogue sites, but still have a very secure, even more secure internet architecture. And that's the result we want. We want a result that protects consumers and also gives them a secure internet experience.
All right, Mr. Sohn, if I could, well, hopefully I can get this question in. The issue of diplomacy. And cooperative approaches. If you look at attachment 8 to Mr. Huntsberry's testimony, which lists reasons why Private Bay, based in Sweden, refuses to comply with DMCA takedown requests from copyright owners. It says it's not a U.S. company, and damned if it has to follow U.S. law. It will not comply with requests to take down unlawful material, and then proceeds to call the victims of that theft morons and suggest a number of acts which I'd prefer not to repeat in public. But it is an attachment 8 for those who want to read it. What do we ask the government of Sweden to do? If they don't do it, do we put them on the USTR's 301 list? Lay out the diplomatic strategy that might work in all the remaining time that you have.
Right. No, I think absolutely what you try to do is work with Swedish authorities to identify the people behind the site and actually go after the individuals. I mean, that's where you have a real deterrent effect, and that's where you have the ability to seize the computer servers that the bad guys are using. My understanding is that in a number of ICE actions, they've done exactly this. They've cooperated with the Netherlands, for example, in connection with some of the recent domain name seizures. They've also actually taken down some bad guys in cooperation with foreign authorities. And I guess
In fact, we have a good example. WikiLeaks, they go after him on sexual misconduct charges.
You know, ultimately, I think it is very difficult to use the DNS system in a way that's going to effectively make these sites inaccessible. That's why I'm saying we have to do the hard work of actually trying to get the bad guys, because I think that however much we might like to use the DNS for that purpose, it's not ultimately going to work.
I think my time's more than expired.
I thank the gentleman. Very pertinent question. The chair now recognizes the gentleman from Arizona, Mr. Quayle, for 5 minutes.
Thank you, Mr. Chairman. Thanks to all of you for coming. Mr. Sohn, during your testimony, you were talking about how we shouldn't be overreaching in any law just to go after a few bad actors. And I found that curious that you said a few bad actors, because, I mean, if you're basing it on, in comparison to everybody who uses the internet, I think that that might be accurate. But when you're actually basing it on, you know, people who are legitimately using copyrighted material, do you still believe that it is just a few bad actors, not a large number of people or entities that are doing this?
Well, it's interesting. I think there are certainly a large number of users that engage in infringement. There was a recent study that looked at a couple of the top BitTorrent sites and found that actually a relatively small number of users, on the order of 100, were responsible for uploading the large majority of the infringing material that was found there. So it does appear that there are some power users who are, you know, they're just burning up their internet connection trying to upload pirated stuff day in and day out. So I do think that going after some of the worst can both make a dent in the problem. I also think that's where you send a strong deterrence message to everybody else to say, look, you're not as anonymous as you think we are. We will go through the effort to track you down, and we can shut you down. And if we do come after you, there's going to be criminal penalties to pay.
And going to the whole shutting down part, and in your testimony, you also presented several reasons why domain name seizures would not be 100% effective, and focus primarily on how such a block might be circumvented. Can you give other examples of situations where authorities should not take action against criminals because they can find a way around it?
I certainly don't think that a law enforcement action has to be 100% effective in order to be worth taking. I do think, though, that at the outset, when we're talking about what new authorities could we create, we'd want to at least make sure it meets a certain minimum bar of effectiveness. And I guess my argument would be not that domain name seizures and blocking are less than 100% effective, but that it's really going to be hardly effective at all. That if you had a graph, you'd see a brief dip, and then you'll see piracy levels go right back up, because it's so easy to circumvent for everyone in the system. And at the end of the day, what I think would happen is if domain name seizures and blocking are something that happen on an occasional basis, I don't think that causes any great consequence. I think if that becomes a mainstream tool of law enforcement, it will lose all of its bite. People would just build other ways around the navigation system. To use an analogy that Mr. Castro brought up, he said it's kind of like taking some of the bad guys' numbers out of the phone book. It is kind of like that, but unfortunately on the internet there's lots of ways to get information, right? You don't have to use the phone book. There's lots of navigation opportunities to find out how to get to these sites. So just purely on a practical level, I think that it's not a tactic that's effective enough to be worth the risks that it causes.
So you don't have any examples of other laws where we cannot push for it without 100% ability to not have any circumvention of that law?
I mean, I think when Congress weighs legislation on a daily basis, probably the scrap heap floor is littered with examples where we thought of ideas and decided they wouldn't work.
Okay, thanks. Now, Ms. Palante, I was just wondering, go back to the illegal streaming. As technology advances, do you think that illegal streaming of copyrighted material is now the primary chosen method to actually use and deliver those copyrighted material over the internet?
I think for some works it will be. I'm not sure. I'm sure Mr. Huntsberry can tell us what the breakdown is between downloading and streaming for the movies. For television programming and for sports streaming, it's very, very big.
And so if that continues to kind of be the wave of the future, do you think that it makes sense to actually have a lesser penalty for those that illegally stream videos or stream copyrighted content over the internet rather than those that provide it in downloaded form?
Thank you for that question. If that is a business model that is a primary way for bad actors to pirate material and to make it available without authorization, it doesn't make sense from a policy perspective for that to be a misdemeanor and not a felony, as is the reproduction and distribution right under copyright law.
Okay, thank you very much. I yield back.
The gentleman from Florida, Mr. Deutsch, is recognized for 5 minutes. He's ahead of her.
He's asking you to defer to Thank you, Mr. Chairman. Mr. Stone, you say in your written testimony that quantifying the problem is exceedingly difficult, and you point out that parties commissioning studies that show the impact of this type of piracy have vested interest in the results, seeming to suggest that perhaps we're taking this more seriously than we ought to. I guess, Mr. Huntsberry, let me actually turn to you. Can you speak to the vested interest that might exist here, and can you talk for a moment about the overall impact on our economy?
Well, I can tell you that there are a lot of jobs at stake, and they occur at different levels. So, for one, you have the films themselves that, as I said, hire between a few hundred up to 5,000 employees to actually produce a movie. And so as volume of films decreases, there's a direct correlation to the number of people who are being hired to make those films. The second part is that at a local level, when we produce films in the 50 states, we are not spending money in those states, i.e. not hiring people in those states. And then finally also at the studio level, where you have people that are in the business of helping to produce those movies, market and distribute them. And you have a direct impact there as well, and we've seen decreases in the last 2 years in that.
Mr. Sun, you can agree there's no reason for us to argue about the relative impact that this is a vitally important issue we ought to be tackling?
It's an important issue, and my only point was to try to emphasize that I think that some of the specific statistics that get thrown around, when the GAO looked at it, the GAO said we can't really verify any of these statistics.
Well, Congressman, may I just add something to that? In fact, it plays also to a question that was raised earlier. We last year, just Paramount alone, we actually issued 40 million infringement notices. Now, infringement notices are specifically targeted at peer-to-peer sites or users of peer-to-peer networks who are downloading content. So we issue the notice to the ISPs, who then forwards it to the consumer. With respect to cyberlockers, which are the online storage sites, we issued 1.5 million takedown notices. That means there were 1.5 million places where anybody in the world would have been able to stream or download the movie.
And so I want to go back, Mr. Sun. You point out in your written testimony that in 2007 and 2008, which is generations ago in terms of what we're combating, what we're dealing with now, particularly in terms of cyber lockers and video streaming, that CDT compiled a music download warning list. Now, if you agree that the primary focus here ought to be on addressing, focusing the rogue sites so that they can't make a profit, make this a profitable enterprise, which you said earlier, shouldn't we be looking not only at advertising, which you point out we should, but shouldn't we also be looking at the ways that they ultimately do make this a profitable venture, which is making people driving traffic to their site? Isn't there an opportunity for the internet service providers to be involved here? Why shouldn't we be focusing on that component as well, since without those ISPs and without a discussion about the various ways that we can ensure that these sites don't come up and we can watch pirated content in 1 or 2 clicks, without that, these aren't profitable ventures. Shouldn't that be a key piece of this legislation?
Well, the hard question there is, what is the role that ISPs could play that would be effective? Because again, the kind of DNS blocking that was suggested in the Senate bill last year, I think just doesn't have any ultimate effectiveness if you actually track through what would likely happen and if you look at the many ways to avoid it.
Let me just interrupt you for a second because I'm running out of time. Instead of, it seems that you're bending over backwards to acknowledge that there are lots of ways to get around efforts that we might wish to take in order to make this a less profitable venture. Shouldn't we be looking at it the other way to come up with the technological ways that we can make it more difficult for others to access this, as Mr. Castro points out, is eminently doable?
I guess I disagree with Mr. Castro that it's eminently doable to make sites hard to reach. If you look at something like the WikiLeaks controversy, the lesson is it's very hard on the internet to just make stuff not reachable. That's why I think the more effective approach would be to say, if they can't process payments, for example, if they can't...
I understand.
So,
I understand that part of your testimony. Can you get back to the ISPs, please?
Right. So on the ISPs specifically, I think that it's very difficult to figure out how ISPs could actually, block people from getting somewhere in a way that wouldn't be overbroad and have a lot of collateral consequences.
Okay, I understand it's difficult. If there's a way that it can be done without the collateral damage that you fear, obviously that should be something that we consider.
I think it's worth considering. I think what Congress will probably find as it looks at that is that those collateral damages, if you're looking at it at the ISP level, are difficult.
Thank you. I yield back, Mr. Chair.
I thank the gentleman. The chair recognizes the gentlewoman from California, Ms. Chu, for 5 minutes.
Thank you, Mr. Chair. I wanted to follow up with you, Mr. Huntsbury, about the true economic impact of piracy. And the reason I wanted to get more deeply into it is I represent a district in Los Angeles County. There are many, many jobs that are related to the entertainment industry. And, of course, Paramount Studios is headquartered in Los Angeles County. So what happens to you certainly has a great deal of impact on my constituents. So in your recent, in your written testimony, you talk about the pre-production investment by the studio. Taking an award-winning movie like True Grit as an example, can you describe the investment for this committee?
Sure. I mean, as you said, True Grit was shot in Texas and New Mexico, but then also produced in Los Angeles, so it had an impact on multiple economies. In the case of True Grit, we would have been spending in Texas and New Mexico on hiring local laborers to build sets. That would include carpenters, that would include painters, that would include set designers, it would include caterers, and so forth. In other words, these are literally tens, sometimes hundreds of people that we have to have on the set, on location, to service the production of the movie. And so It is, again, it is like in the case of True Grit, it was an impact of $16 million between those two states alone. That's not accounting for what we spent in Los Angeles, which was even more than that.
Mm. And I understand residuals from DVD sales are an important part of the compensation package for actors, directors, electricians, painters.
Absolutely. The guild members, as well as the union members, are compensated as a percentage of the revenues that we draw from DVD sales or from the sales of the movies in general.
I understand True Grit was officially released on December 22nd, 2010. How long did it take before the movie was available online for free?
It turned out that in the case of True Grit, it took about 5 days, and it was a copy of a screener that we had sent out to Academy members for the voting. And the screener, by the way, was copyright protected.
Thank you. I yield back.
Thank you. The gentlewoman from California, Ms. Lofgren, is recognized for 5 minutes.
Well, thank you very much, Mr. Chairman. This is, I have so many questions. I hope I can get them out and get answers promptly. Mr. Huntsbury, I'm wondering, the Senate bill last year would have given government the exclusive power to initiate legal actions to block domains. Is this satisfactory to you, or do you believe that there should be a private right of action to obtain DNS blocking orders?
Well, first of all,
if you could just say yes or no. I mean, I've only got 5 minutes.
we don't know yet.
You don't know. Okay. I'm wondering, you have your 20 slides, and I'm wondering, of those, according to your written testimony, it's about 90% of what's of concern was represented in those 20 slides. How many lawsuits have been brought against the actors in those 20 slides?
Against the what? I'm sorry?
The actors that you identified in your slides. How many lawsuits?
It's not a number that I could quote you here right now, but it is a large number.
Could you provide it to me later?
Absolutely.
Thank you very much. I appreciate it. I'm wondering about digital locker sites. Do you believe that Congress should give the government the right or power to seize those domains, even if they comply with the DMCA?
Well, today they don't comply with the DMCA.
But the question is, if you do give a notice and takedown and they comply, do you think they still ought to be subject to blocking?
If complied is defined as that you can no longer find stolen content on the site, then yes.
You said in your testimony that even with DMCA takedowns, there is never a moment that stolen copies of True Grit are not accessible. Is your goal really to make sure that there is not available anywhere a stolen copy of True Grit? Do you think that is achievable?
What we're trying to do, we're trying to level the playing field here between the good guys and the bad guys. Today, even after 40 million infringement notices and 1.5 million takedown notices, the films are still available. So what it has proven so far is that we are not able just simply with these notices to bring the problem to a halt.
You know, I do think that we have a problem here, and the question I'm trying to get at is what's an adequate remedy that doesn't cause collateral damage. And I think about, we've heard from Hollywood, and that's an extremely important industry for the United States. There is no question about it. I hear from my constituency more about software, because there's certainly a theft problem there. But we've gone round and round with my software constituents and finally agreed that although it's always wrong to have piracy, not every piracy is a lost sale, because a lot of what is taken would never have been sold. It doesn't mean that it's right to do it, but it is worth putting a grain of salt, as the GAO has done in terms of the dollar loss. Thinking about that, how do we focus on dealing with bad actors without avoiding the collateral damage. As I was listening to some of our freshman members about illegal, I was designing this scenario in my mind. You have a Tea Party website, and they are running without authorization clips of the Patriot to inspire those who come to their website. And they're also ad-supported. Republican candidates are buying ads on the site, and they're soliciting funds from people who visit the site, and they're also hosting blogs from people who believe in the Tea Party principles. They violated the Copyright Act. They're subject to blockage, if I'm reading the Senate bill correctly, and yet there would be significant First Amendment collateral damage. How would you deal with that, Mr. Sohn, that scenario?
Well, I think at a minimum, any step that Congress takes here needs a much narrower definition than the Senate bill contained of what constitutes a website dedicated to infringing activity. The Senate bill used that phrase, website dedicated to infringing activity, but I think I fear the actual definition they used was much broader than that and could apply to any of a range of sites that do a range of things and then happen to get some infringement on them because users post some there.
For example, and I notice this is not just foreign nationals. I mean, most of the companies listed on the site are California companies. I mean, Google and Netflix and on and on and on. Facebook, I mean, Facebook has tons of infringing material on it that people have uplifted, and yet I wouldn't call Facebook a rogue site, and yet I think it would be subject to the entire site. If ICE is to be believed, that whole thing would be taken down just like BitTorrent, wouldn't it?
Well, there's one certainly hopes that law enforcement would not pursue a case like that, but there's no question that.
But how are the facts any different?
Well, and furthermore, the process for seizures is essentially a one-sided process. So law enforcement decides it wants to target a site. It goes in and tells that to the judge. The site can get seized without having an opportunity for the site operator to come in and say, no, wait a minute, here's why I'm actually a lawful enterprise and why you've got this wrong. And I think whenever you have a one-sided process like that, the risk of either mistakes or just over-aggressive action is significant.
I see that the red light is on, Mr. Chairman. I don't want to abuse your courtesy to me. I yield back.
We may have a question or two more here, so the gentlewoman might hang in.
This question from Mr. Sohn.
Mr. Sohn, as you know, ICE has used authority provided by Pro-IP over the past year to seize more than 100 domains that judges found were engaged in online IP theft. In every instance, the domain name owner had the right to petition a federal judge to require the return of the domain name. Can you tell the committee how many of these owners have actually filed such a petition and appeared in federal district court?
It's my understanding that nobody has done that to date.
Is that not an indication that that seizing domain names might be somewhat effective?
Well, the fact that they haven't done it could indicate a number of things. Number one, it could indicate that some of them think that challenging the federal government in a lawsuit is going to be costly litigation, and some of them may figure it is just easier to quit.
Has anyone come forward and said that of these 100 sites, said, we're right, we have a legitimate complaint that our domain name was seized improperly, we're not engaged in facilitating pirated works, yet we don't want to take on the federal government because of the cost or other concerns?
So there are some entities that have publicly said that they believe they are wrongly targeted. There were some music blogs that said that they actually had obtained the material that they posted from the record labels on a promotional basis. There was the example, I guess this is not an intellectual property example, but there was an example just last month of a service called moo.com, which shares a domain among 84,000 registrants, as I mentioned in my testimony, and they had the entire domain got seized because presumably there were some individual sites there that were engaged in that criminal activity. And so a number of innocent individuals were affected there. So there certainly have been cases where innocent individuals have been affected. I actually think the real reason that you probably don't see entities challenging it is, number one, certainly the bulk of them probably are just illegal enterprises, and they have an easy way around it. They can just go register a domain with a foreign registrar that isn't subject to U.S. jurisdiction. So why bother challenging it when you've got an easy route around?
Have we seen, amongst these 100, have we seen evidence of that occurring?
Absolutely.
Mr. Castro, what do you have to say in response to that?
I would say that if the fear is that these sites will go abroad, that's exactly why we need to be blocking these sites. That's specifically the reason that enforcement mechanisms that only target domestic sites and domestic bad actors will ultimately be ineffective. You can think of the problem as having, maybe four.
But what do you say to Mr. Sohn's contention that that's not effective because they simply go and get another domain name and keep right on going?
Well, I would say, this committee could perform an experiment. If you have a domain name that everyone knows, if that disappeared for a day, I'd bet your traffic would disappear as well. I don't think it's that easy for people to find sites when a domain that they know and use is gone.
What do you have to say to that, Mr. Sohn?
Well, I did a little experiment myself after ICE seized, I think, 10 sports streaming domains back in January, and I was curious. By the way, I did not want to engage in piracy on these sites. I just wanted to find out if they had resurfaced somewhere. So I just did a little bit. It really only took 5-10 minutes of sleuthing on the internet, if that, really just a few searches. And what I discovered was that there were plenty of people out there discussing precisely this issue, people who had various posts and comments, various places, saying, hey, where'd that site go? And someone answers the question, says, well, it's moved, it's now located at this other foreign top-level domain. So what I found was, in looking at those sites, it was actually quite easy to figure out where they had gone. And this kind of gets back to my point.
But no one knows what happened to the volume at the site. I mean, I understand that the more dedicated person would do exactly what you're talking about, and they'll find the new domain name and the new address and reach it fairly easily. But the more casual customer can't find the site. Is that having an effect? Is that reducing the volume of piracy, or is it not? I think that's a question I'd like to have an answer to. Mr. Hunsberry?
Yes, I think that's precisely the point. We know that theft is always part of the business model. It's no different than in the brick-and-mortar business. Brick-and-mortar every day has to deal with theft. And so this will also occur in the online space. What we're trying to do here is level the playing field so that at least the average consumer is doing the right thing. The bad guys will always find ways to find the content.
And what do you and Mr. Castro have to say about the collateral damage that Mr. Sohn cited with regard to a domain name that's shared and one violator messed up the other 63? Or how many? You said more than 63. You had a...
There were 84,000 registrations.
84,000 registrants.
Domain.
Sure. What you have to do in this case is you want to make sure there's the right kind of processes in place. And this is something that this committee can exactly work on. How can you set up the right processes so mistakes aren't made? Certainly in law enforcement, this isn't the first time mistakes were made. This won't be the last time. But the idea that free speech trumps theft is, I think, absolutely ridiculous. And there's no reason we can't take action.
Thank you. Mr. Watt, does that prompt any further questions?
Yeah, let me pick up on right there, because really the question I was trying to get to, or wanted to get to, is how can we set up a due process mechanism that takes these things into account? What would be the ideal due process mechanism, Mr. Sohn, that how would you change the current process that ICE is authorized or is undertaking?
I mean, the ideal due process mechanism is always to let the defendant have his day in court, essentially, and come in and explain why it's not actually.
All right, so if we gave, and what's the problem with doing that, Mr. Castro? I mean, if I go to a judge and I've got a captive judge and I got all the facts and no opportunity for anybody on the other side to respond, that says, hey, I'm legitimate, I got free speech issues. How do those issues ever get raised before the takedown?
I think there's a number of things you have to keep in mind. If you're talking about domestic sites, you know, you have to have processes that can respond in internet time. You have to have, I think.
Well, you got to tell me what the processes are. That's
So
what we're
one of
here
those-
for. We're trying to set up a mechanism now. I don't mean to be impatient like Mr. Conyers has been, but you can't just tell me you got to do this. You got to do this. I don't understand what it is you're asking me to do.
Sure. So I think the right solution would be that you could,
And I'm, while I think I agree with you that most of the First Amendment defenses are crap, even though I'm probably the biggest First Amendment defender on this committee, or one of them at least, I would think. But I'm not much on allowing somebody's property to be taken without some kind of opportunity to defend themselves. I'm kind of on both sides of this issue with you and Mr. Son, but you got to tell me how to get around this. If one side can go to a judge and get an immediate order, it seems to me that the other side could come to that same judge and defend themselves immediately. That's internet fast time, I would take it. Are you advocating something different than that?
well, I think there's a number of things you could do. One thing you could do is you could set a limit on how long you could have a site taken down without, you know, the right to appear before a judge.
But once the site's taken down, the damage is done if it's done wrong.
Well, you could do it a very short site. You could have administrative and other kinds of reviews before it could be taken down in the first place. And you could also, of course, have liability.
Well, that's what I'm asking you. You're
Well, I'm
telling me
saying all
telling me
three
you
of them.
can't get an administrative review. What's a judge? That's an administrative review.
Well, before it's done internally.
Before it's done internally. That's right.
Right.
Why can't I, as the site owner, have the opportunity to appear and present my side at that administrative review?
You could certainly do that.
Okay. All right. So you all are saying the same thing then. I mean, that satisfies you, Mr. Son?
I think that, yeah, that would be a very important
Then we finally got some reconciliation that satisfies you, Mr. Huntsberry?
I think I'm not prepared yet to agree with my colleague here at this point. Because
Well, are you disagreeing with him, or are you just not prepared to agree with him?
No. I think that, look, I think due process is.
Because you told Ms. Lofgren that too. You didn't have an answer to a question. Now, we need you to answer questions here today. Otherwise, we won't get anywhere.
So again, the parallel I like to draw here is that if a store is selling.
I don't want you to draw parallels. I want you to tell me how I can do this and give due process and give you what you're looking for at the same time.
I think that once a site has been blocked, I think very quickly the site owner has the ability to say, was it done justly or not done justly?
But the blockage of the site for somebody who is legitimate, to give them the opportunity the next day to come back and say you really blew this up, you screwed up, I don't think is fair.
But we know today who is stealing our content. It is very obvious to us because we know exactly who we license to. Therefore, any site we find our content that we do not license to is stealing our content.
Even the Facebook Tea Party people that Ms. Lofgren described?
Again, it's like if we know
Wait a minute now,
our
come
content
on.
is on a site that we have not licensed to, we know that it is fraud.
Even if it's the Tea Party people on the Facebook site that Ms. Lofgren described, that you said you didn't have an opinion about yet.
And I still don't have one.
Well, but you just made a very broad statement. Anybody who puts something up that you haven't licensed is violating your license.
That's true, because that is how the licensing agreement is reached. It is reached formally between the studio and the site. And to the extent that the site has not entered into a license.
So if law enforcement is going to go out and seize that site, the Facebook site that Ms. Lofgren described, without a hearing, and without that person, without the Tea Party or whoever it is being able to come in and say, this is legitimate First Amendment protected, you would say they are violating it and they shouldn't be given that right?
They should absolutely be given the right to speak. I think what we're talking about is
But
before.
2
after
days
the
later, you want to be
Correct.
given the right.
To me, it should be the day after.
The day after.
Absolutely. It should be after the seizure.
I don't know about
Because
that.
that's also, if we look at
Huntsberry.
what has
Mr.
happened.
Castro, you wanted to make a point. Go ahead.
I just wanted to say that if you look at physical goods, physical goods are seized before there's court review. So if you want to have a similar system.
I wasn't too hot on that process either.
Right.
I'm at least,
Right. Well,
I try to be consistent in the way, I'm not a big pre-seizure person. I never have thought that it was all that fair.
Sure. In the
Even if
physical
you're
world-
seizing unlawful stuff, you ought to give people an opportunity to tell people that it's not unlawful. Anyway, my time has expired, and I'm far over. But I wanted to ask Mr. Huntsberry one other question. You can answer for the record.
Go ahead.
I'm trying to find out what authority you are advocating for on the civil side. I heard you say authorized law enforcement to go do stuff in foreign countries. I need to know what authority you need on the non-law enforcement side that you don't currently have. So, we don't have time to have you answer that now, and you didn't seem to have a lot of opinions about a lot of this stuff anyway, so this will give you a chance to answer some of the questions that you haven't formulated opinions about. And that's one you can spend several days and then get back to us about.
We will afford all the members of the subcommittee the opportunity to submit questions in writing, and we will afford you an opportunity to respond. Let me see if anyone has a question they'd like to ask right now. The gentleman from Florida.
Thank you, Mr. Chairman. It's a fascinating conversation about whether or not the government has the right to shut down Facebook. But I believe that we've gone slightly astray here. Mr. Stone, let me ask you a question. When CDT put out that list of 47 sites that were falsely posing as legitimate music stores, which is the way your testimony describes it, you put that list together. When you put that list out, were you worried that these might be legitimate sites that somehow by an organization like yours putting on this list that somehow you might be doing damage to them?
Well, I will say first, we did some due diligence there.
I understand that. You did due diligence. Of course you did. And would we be wrong to suggest or to believe that there is a difference between something that might get posted on Facebook and what Solar Movie does, or what a movie site that clearly is illegally streaming movies is doing, number one, or a book site that is clearly permitting the illegal downloading of copyrighted material, or in the case of music, a site that is clearly permitting the illegal downloading of music without the respect for the intellectual property there. Aren't there instances where, yes, we need to be worried about the broader implications and making sure we get it right, but aren't there instances where we ought to have enough faith in the federal government that they, just like CDT, could get it right?
Well, I think there is a big difference between a private actor taking action, a small group like ours, and the federal government taking action. And
right,
and
I'm sorry, Mr. Stone, and that's, I agree, and just, Mr. Chair, if I may, I agree that there is a difference. And I don't know about CDT's ability to to do their due diligence before putting out a list. But I believe that probably most of us here would acknowledge that there's no one who has more resources at their disposal than the federal government in compiling such a list, number one. And number two, with respect to some of these very specific sites where there is nothing except what's illegal being done, clearly we ought to be in a position to acknowledge that, and the federal government ought to be in a position to make that determination before moving forward on shutting down that domain name.
I think whenever you have government action involved, you do want to have due process. You want to have some procedural guarantees of fairness. And, you know, unfortunately, we have already seen an example where the federal government made a mistake here. It went after moo.com, and there were lots of innocent users of that. Why? Because they didn't quite understand that this was I think, because they didn't quite understand because that this domain was shared between many users. So I think anytime you don't have due process, there are risks.
Right. Mr. Chairman, I just, before yielding back, I would acknowledge, I would just point out that I think this hearing was incredibly helpful in starting to flesh out some of the tough issues that we need to grapple with. At the same time, I think also putting us in a position to realize that if we grapple with those issues, that we can draft legislation that will be respectful of due process, that will build in sufficient due process, but will also permit us to protect the intellectual property rights that are being violated every single day. And I yield back. Thank you.
Well said. The gentlewoman from California.
Thank you, Mr. Chairman. I realize that I wanted to ask the Ms. Palante if you mentioned that you'd convened a group of stakeholders, a large number, I can't remember the number you said. Could you provide later a list of who those stakeholders were that you met with?
Yes, I'd be happy to.
Thank you very much. You know, I was thinking about the DMCA, and I remember very well, Mr. Chairman, I was a freshman, but the years that we spent trying to sort through that, and although I don't think it was perfect, by the time we finished it, it was a lot better than it was when it started. I mean, the original draft outlawed web browsing, although I don't think it intended to. Now we're being asked for new remedies, and the question isn't whether we shouldn't consider remedies, but whether they're narrowly tailored to deal with a specific problem and we won't have collateral damage. That's, I think, one of the big issues. And I was interested in, this is a rough, I didn't write down word for word, but that search engines and ISPs should be required to prevent access to the bad actors, essentially that was asserted as something that should happen. And in thinking about that, since the bad actors are not a static list, I mean, there's constant movement in the internet, I'm wondering how that squares with the Supreme Court's decision in the Betamax case that basically says that technologies capable of substantial non-infringing uses are not inherently guilty of copyright infringement. And really our position as a government has been that we are not going to either shut down non-infringing technologies if they have substantial non-infringing uses, nor are we going to go in and do the engineering from the government's point of view of technologies that are in that category. How does that precedent square with the assertion that we should require ISPs and search engines to block an ever-expanding list and technologies we probably haven't even thought of? Can you think of that, Mr. Son, how that would work?
Yeah, I think you raise a very good point. There's a long tradition in this country of dealing with internet service providers and information tools like that in a certain way. We have the DMCA that's addressed that. I do think that one risk is that the current legislative process could take us into really groundbreaking territory where, you know, we toss aside some of our long-standing principles regarding how the internet operates and how ISPs and intermediaries in the online context work. One of the fears that I've tried to express here is that I think that that some of those proposals just wouldn't work anyway. And so it's asking us to really do a sea change in our legal approach to some of these entities for results that I actually don't think would make much difference in infringement.
One of the things that I think, and I think Mr. Deutsch mentioned it and others, the utility of really addressing the payment scheme. And that intrigues me as an opportunity, because if you do have a site where you're getting paid to stream or to download material that you don't have a right to profit from, that is an opportunity, you know, it seems to me, to deal with it. Visa came into my office, and I didn't talk to their representatives, but they talked to my staff last week and said they're watching the Senate bill, that in the last 6 months, they have been asked only 30 times they've got a voluntary system where they will block payment for infringing uses, but they've only been asked 30 times in the last 6 months to do that. So I'm wondering why would that be? And are we using the tools that have already been made available? I mean, apparently they're not very agitated about this bill because they don't feel it would, I don't want to speak for them, but my impression was they didn't think it'd be a big burden because nobody's asking them to do it now and they're willing to do it. Maybe you can comment on that, Mr. Huntberry. Do you know why only 30 times would Visa have been asked to block these sites?
No, as a matter of fact, we have been in contact with Visa intensively over the last year, and also, I should say, with MasterCard. And I will say that MasterCard has done amazing steps forward in correcting this situation. So we absolutely agree with you that this is a very good area, as is, by the way, working with the ad providers, because advertising revenue is another type of revenue that these sites benefit from.
I know my time is up. I would just like to make one comment that you're right. I mean, you've got counterfeit goods. We don't have a due process issue when you've got counterfeit goods, but you never have a problem usually that counterfeit goods could be engaging in First Amendment rights activity. It's a whole different type of risk that we have as a country when we move into this. And some of the, there is a concept of fair use in the United States, that it is possible to use some material and have it be protected by the First Amendment. That's been really not mentioned here today. And just a final thought, if we move into designing technology by the United States government, that too will move offshore. As we know, Mr. Chairman, not all engineers currently live in the United States, not all technology is designed in the United States. That's another collateral issue that we should be discussing and mindful of as we continue to discuss this important issue. And I yield back with thanks.
Well, I thank the gentlewoman. I thank all the members of the panel. This has been a very good hearing. I agree with some of the members who said that a number of good ideas have been discussed here, a number of good caveats about how to make sure we don't violate legitimate operators' due process have been brought forward as well. And I would encourage everybody involved here, the internet service providers, the content owners, everyone to find as many business model solutions to this problem as possible as well, because while it is imperative that this committee act, and I believe that we will act in this area, and the Senate is hard at work on this as well, that just like with the DMCA, we won't find all the solutions here. They're going to have to be found through the use of technology and through the use of better business models to protect intellectual property as well. So I thank everybody for their contribution today. We will be hard at work at this. This is not our last hearing on this subject, and we will be working on legislation. I would like to thank our witnesses for their testimony today. Without objection, all members will have 5 legislative days to submit to the chair additional written questions, which we will forward to the witnesses and ask them to respond to as promptly as possible so that their answers may be made a part of the record. And without objection, all members will have 5 legislative days to submit additional materials for inclusion in the record. And with that, I again thank the witnesses and adjourn the hearing.